The Constitution of India, Part 4, The States, Chapter 1, General, Article 152, Definition. In this part, unless the context otherwise requires, the expression state does not include the state of Jammu and Kashmir. Chapter 2, The Executive, the Governor. Article 153, Governor of States. There shall be a governor for each state, provided that nothing in this article shall prevent the appointment of the same person as governor for two or more states. 154. Executive power of state. 1. The executive power of the state shall be vested in the governor and shall be executed by him either directly or through officers subordinate to him in accordance with the Constitution. 2. Nothing in this article shall a. be deemed to transfer the governor any function conferred by any existing law on any other authority, or b. prevent parliament or the legislature of the state from conferring by law functions on any authority subordinate to the governor. 155. Appointment of governor. The governor of a state shall be appointed by the president by warrant under his hand and seal. 156. Term of office of governor. 1. The governor shall hold office during the pleasure of the president. 2. The governor may, by writing under his hand, address to the president, resign his office. 3. Subject to the foregoing provisions of this article, the governor shall hold office for a term of 5 years from the date on which he enters upon his office. Provided that a governor shall, notwithstanding the expiration of his term, continue to hold office until his successor enters upon his office. 157. Qualification for appointment as governor. No person shall be eligible for appointment as governor unless he is a citizen of India and has completed the age of 35 years. 158. Conditions of governor's office. The governor shall not be a member of either House of Parliament or of a House of the Legislature of any state specified in the first schedule, and if a member of either House of Parliament or of a House of the Legislature of any such state be appointed governor, he shall be deemed to have vacant his seat in that house on the date on which he enters upon his office as governor. 2. The governor shall not hold any other office of profit. 3. The governor shall be entitled without payment of rent to the use of his official residence, and shall be also entitled to such emoluments, allowances and privileges as may be determined by Parliament by law and until provisions in that behalf is so made. Such emoluments, allowances and privileges as are specified in the second schedule 3A, where the some person is appointed as governor of two or more states, the emoluments and allowances payable to the governor shall be allocated among the states in such proportion as the president may by order determine. 4. The emoluments and allowances of the governor shall not be diminished during his term of office. 159. Oath or affirmation by the governor. Every governor and every person discharging the functions of the governor shall, before entering upon his office, make and subscribes in the presence of the Chief Justice of the High Court exercising jurisdiction in relation to the state, or in his absence the senior most judge of the court available, an oath or affirmation in the following form, that is to say, I.A.B. do swear in the name of God that I will faithfully execute the solemnly affirm I will faithfully execute the office of governor or discharge the functions of the governor of ABC name of the state, and will to the best of my ability presence protect and defend the Constitution and the law, and I will devote myself to the service and well-being of the people of name of the state. 160. Discharge of the functions of the governor in certain contingencies. The President may make such provisions as he think fit for the discharge of the functions of the governor of state in any contingencies not provided for this chapter. Article 161. Power of governor to grant pardons, etc., and to suspend, remit, or commute sentences in certain cases. The governor of a state shall have the power to grant pardons, reprieve, respites, or remissions of punishment, or to suspend, remit, or commute the sentence of any person convicted of my office against any law relating to a matter to which the executive power of state extend. 162. Extent of executive power of state. Subject to the provisions of this Constitution, the executive power of state shall extend to the matters with respect to which the legislature of state has power to make laws, provided that in any matter with respect to which the legislature of state and parliament have power to make laws, the executive power of state shall be subjected to and limited by the executive power expressly conferred by this Constitution or by any law made by Parliament upon the Union or authorities thereof. Council of Ministers. Article 163. Council of Ministers to aid and advise Governor. 1. There shall be a Council of Ministers with the Chief Minister as the head to aid and advise the Governor in the exercise of his functions, except in so far as he is by or under the Constitution required to exercise his functions, or any of them in his discretion. 2. If any questions arise where any matter is or is not a matter as respect which the governor is by or under this Constitution required to act in his discretion, the decision of the governor in his creation shall be final, and the validity of anything done by the governor shall not be called in questions on the ground that he ought or ought not to have acted in his discretion. 3. The question whether any, and if so what, advice was tendered by ministers to the governor shall not be inquired into in any court. Article 164. Other provisions as to the ministers. 1. The chief minister shall be appointed by the governor, and the other ministers shall be appointed by the governor on the advice of chief minister, and the ministers shall hold office during the pleasure of the governor, provided that in the states of Chhattisgarh, Jharkhand, Madhya Pradesh and Odisha there shall be a minister in charge of tribal welfare, who may in addition be in charge of the welfare of scheduled caste and backward class or any other work. 1a. The total number of ministers, including the chief minister, in the council of ministers in a state shall not exceed 15% of the total number of members of the legislative assembly of that state, provided that a number of ministers, including the chief minister in a state, shall not be less than 12. Provided further that where the total number of ministers, including the chief minister in the council of ministers in any state at the commencement of the constitution 91st Amendment Act 2003 exceed the said 15% or the number specified in the first proviso, as the case may be, then the total number of ministers in that state shall be brought in conformity with the provisions of this clause within 6 months from such date as the President may by public notification appoint. 1b. A member of the Legislative Assembly of the state or either house of the legislature of a state having legislative council belong to any political party who is disqualified for being a member of that house under paragraph 2 of the 10th schedule shall also be disqualified to be appointed as minister under clauses 1 for duration of the period commencing from the date of his qualification till the date on which the term of his office as such member would expire, or where he contends any election to the legislative assembly of the state or either house of the legislature of a state having legislative council, as the case may be, before the expiry of such period till the date on which he is declared elected, whichever is earlier. 2. The council of ministers shall be collectively responsible to legislative assembly of the state. 3. Before a minister enter upon his office, the governor shall administer to him the oaths of office and of secrecy according to the forms set out for the purpose in the 3rd schedule. 4. A minister who for any period of 6 consecutive months is not a member of the legislature of the state shall at the expiration of the period cease to be a minister. 5. The salaries and allowances of ministers shall be such as the legislature of the state may from time to time by law determined and until the legislature of state so determine shall be as specified in the second scheduled. The Advocate General for the state. Article 165. Advocate General for the state. 1. The governor of each state shall appoint a person who is qualified to be appointed a judge of a high court to be Advocate General for the state. 2. It shall be the duty of the Advocate General to give advice to the governor of the state upon such legal matters and to perform such other duties of legal character as many from time to time be referred or assigned to him by the governor, and to discharge the functions conferred on him by or under this constitution or any other law for the time being in force. 3. The Advocate General shall hold office during the pleasure of the governor and shall receive such remuneration as the governor may determine. Conduct of government businesses. Article 166. Conduct of businesses of the government of a state. 1. All executive action of the government of a state shall be expressed to be taken in the name of the governor. 2. Orders and other instruments made and executed in the name of the governor shall be authenticated in such manner as may be specified in rules to be made by the governor, and the validity of an order or instrument which is so authenticated shall not be called in question on the ground that it is not an order or instrument made or executed by the governor. 3. The governor shall make rules for the more convenient transaction of the business of the government of the state and for the allocation among ministers of the said business in so far as it is not business with respect to achieve the governor is by or under the constitution required to act in which discretion. Article 167. Duties of Chief Minister as respects the furnishing of information to governor etc. It shall be the duty of the Chief Minister of each state A. To communicate to the governor of state all decisions of the Council of Ministers relating to the administration of the affair of the state and proposal of legislation. B. To furnish such information relating to the administration of the affairs of state and proposals of legislation as the governor may call for, and C. If the governor so requires, to submit for the consideration of the Council of Ministers any matter on which a decision has been taken by the minister but which has not been considered by the council. Chapter 3. The State Legislature General. Article 168. Constitution of Legislature in States. 1. For every state there shall be a legislature which shall consist of the governor and A. In the states of Andhra Pradesh, Bihar, Madhya Pradesh, Maharashtra, Karnataka, Tamil Nadu, Telangana and Uttar Pradesh, 2 houses. B. In other states, 1 houses. 2. Where there are 2 houses of legislature of a state, one shall be known as the legislative council and the other as the legislative assembly, and where there is only one house, it shall be known as a legislative assembly. Article 169. Abolition or creation of legislative council in states. 1. Notwithstanding anything in Article 168, Parliament may by law provide for the abolition of the legislative council of a state having such a council, or for the creation of such a council in a state having no such council, if the legislative assembly of the state passes a resolution to that effect by a majority of the total membership of the assembly and by a majority of not less than two-thirds of the members of the assembly present and voting. 2. Any law referred to in clause A shall contain such provisions for amendment of this constitution as may be necessary to give effect to the provisions of the law, and may also contain such supplemental, incidental and consequential provisions as Parliament may deem necessary. 3. No such laws as aforesaid shall be deemed to be an amendment of this constitution for the purpose of Article 368. Article 170. Composition of legislative assemblies. 1. Subject to the provisions of Article 333, the legislative assembly of each state shall consist of not more than 500 and not less than 60 members chosen by direct election from the territorial constituency in the state. 2. For the purpose of clause 1, each state shall be divided into territorial constituencies in such manner that the ratio between the population of each constituency and the number of seats allotted to it shall, so far as prescribed, be the same throughout the state. Explanation. In this clause, the expression population means the population as ascertained at the last preceding census of which the relevant figures have been published. Provided that the reference in this explanation to the last preceding census of which the relevant figures have been published shall, until the relevant figure for the first census taken after the year 2026 have been published, by construed as a reference to the 2001 census. 3. Upon the completion of each census, the total number of seats in the legislative assembly of each state and the division of each state into territorial constituencies shall be readjusted by such authority and in such manner as Parliament may by law determine, provided that such adjustment shall not affect representation in the legislative assembly until the dissolution of the then existing assembly. Provided further that such adjustment shall take effect from such date as the Parliament may by order specify, and until such readjustment takes effect, any election to the legislative assembly may be held on the basis of the territorial constituency existing before such adjustment. Provided also that until the relevant figures for the first census taken after the year 2026 have been published, it shall not be necessary to readjust. 1. The total number of seats in the legislative assembly of each state as readjusted on the basis of 1971 census, and 2. The division of each state into territorial constituency as may be readjusted on the basis of the 2001 census. Under this clause, Article 171. Article 171. Composition of the Legislative Councils. 1. The total number of members in the Legislative Council of a state having such a council shall not exceed one-third of the total number of members in the Legislative Assembly of the state, provided that the total number of members in the Legislative Council of a state shall in no case be less than 40. 2. Union Parliament by law otherwise provides the composition of the Legislative Council of a state shall be as provided in clauses 3. 3. Of the total number of members of the Legislative Council of a state, a. as nearly as many be one-third shall be elected by the electorates consisting of members of municipalities, district board, and each other local authorities in the state as Parliament may by law specify. B. As nearly as may be, 1/12 shall be elected by the electorates consisting of a person residing in the state who have been for at least 3 years grantees of any university in the territory of India, or have been for the least 3 years in possession of qualifications prescribed by or under any law made by Parliament as equivalent to that of a graduate of any such university. C. As nearly as may be, 1/12 shall be elected by electorate consisting of persons who have been for at least 3 years engaged in the teaching in such educational institution within the state, not lower in standard than that of a secondary school, as may be prescribed by or under any law made by Parliament. D. As nearly as may be, 1/3 shall be elected by the members of the Legislative Assembly of the state from amongst persons who are not members of the Assembly. E. The remainder shall be nominated by the Governor in accordance with the provisions of clauses 5. 4. The members to be elected under sub-clauses A, B and C of the clauses 3 shall be chosen in such territorial constituency as may be prescribed by or under any law made by Parliament, and the elections under the said sub-clauses and sub-clauses D of the said clause shall be held in accordance with the system of proportional representation by means of single transferable vote. 5. The members to be nominated by the Governor under sub-clauses E of clauses 3 shall consist of persons having special knowledge or practical experience in respect of such matters as the following, namely literature, science, art, cooperative movement and social services. Article 172. Duration of state legislatures. 1. Every legislative assembly of every state, unless sooner dissolved, shall continue for 5 years from the date appointed for its first meeting and do no longer, and the expiration of the said period of 5 years shall operate as a dissolution of the assembly, provided that the said period may while a proclamation of emergency is in operation, be extended by the Parliament by law for the period not exceeding 1 year at a time and not extending in any case beyond a period of 6 months after the proclamation has ceased to operate. 2. The Legislative Council of a state shall not be subjected to dissolution, but as nearly as possible one-third of the members thereof shall retire as soon as may be on the expiration of every second year, in accordance with the provisions made in that behalf by Parliament by law. Article 173. Qualification for membership of the state legislature. Article 173. Qualification for membership of the state legislature. A person shall not be qualified to be chosen to fill a seat in the legislature of a state unless he a. is a citizen of India and makes and subscribes before some person authorized in the behalf of the Election Commission or an oath or affirmation according to the form set out for the purpose in the third schedule. B. is in the case of a seat in the Legislative Assembly not less than 25 years of age, and in case of seat in the Legislative Council not less than 30 years of age, and C. possesses such other qualification as may be prescribed in that behalf by or under any law made by Parliament. Article 174. Sessions of the state legislature, prorogation and dissolution. 1. The governor shall form a time to time summon the house of each house of the legislature of the state to meet at such time and place as he thinks fit, but 6 months shall not be intervened between its last sitting in one session and the date appointed for its first sitting in the next session. 2. The governor may from time to time a. prorogue the house or either house, b. dissolve the Legislative Assembly. Article 175. Right of governor to address and send message to the house or houses. 1. The governor may address the Legislative Assembly, or in the case of a state having a Legislative Council, either house of the legislature or of the state or both house assemble together and may for that purpose require the attendance of members. 2. The governor may send message to the house or houses of legislature of the state, whether with respect to a bill then pending in the legislature or otherwise, and house to which any message is so sent shall with all convenient dispatch considered any matter required by the message to be taken into consideration. Article 176. Special address by the governor. 1. At the commencement of the first session after each general election, the Legislative Assembly, and at the commencement of the first session of each year, the governor shall address the Legislative Assembly, or in the case of state having Legislative Council, both houses assemble together and inform the legislature of the causes of its summons. 2. Provision shall be made by the rules regulating the procedure of the house or either house of the allotment of time for discussion of the matters referred to in such address. Article 177, rights of minorities and Advocate General as respects the Houses. Every minister and the Advocate General for state shall have the right to speak in and otherwise to take part in the proceeding of legislative assembly of the state, or in the case of a state having a legislative council, both house, and to speak in and otherwise to take part in the proceeding of any committee of the legislature of which he may be named a member, but shall not by virtue of this article be entitled to vote. Officer of the state legislature. Article 178. Article 178. The Speaker and Deputy Speaker of the Legislative Assembly. Every legislative assembly of a state shall, as soon as may be, choose 2 members of the assembly to be respectively Speaker and Deputy Speaker thereof, and so often as the office of Speaker or Deputy Speaker becomes vacant, the assembly shall choose another member to be Speaker or Deputy Speaker as the case may be. Article 179. Vacation and resignation of and removal from the offices of Speaker and Deputy Speaker. A member holding office as Speaker and Deputy Speaker of an assembly A shall vacate his office if he cease to be member of the assembly. B may at any time be writing under his hand address of such member is a speaker to the deputy speaker, and if such member is the deputy speaker, to the speaker resign his office, and C may be removed from his office by resolution of the assembly passed by the majority of all the then members of the assembly, provided that no resolution for the purpose clause C shall be removed unless at least a 14-day notice has been given of the intention to move the resolution. Provided further that whenever the assembly is dissolved, the speaker shall not vacate his office until immediately before the first meeting of the assembly after the dissolution. Article 180. Power of the deputy speaker or other person to perform the duties of the office of or to act as speaker. 1. While the office of speaker is vacant, the duties of the office shall be performed by the deputy speaker, or if the office of deputy speaker is also vacant, by such member of the assembly as the governor may appoint for the purpose. 2. During the absence of a speaker from any sitting of the assembly, the deputy speaker, or if he is also absent, such person as may be determined by the rules of procedure of the assembly, or if no such person is present, such other person as may be determined by the assembly shall act as speaker. Article 181. The speaker or the deputy speaker not to preside while a resolution for his removal from office is under consideration. 1. At any sitting of the legislative assembly, while any resolution for the removal of a speaker from his office is under consideration, the speaker, or while any resolution for the removal of the deputy speaker from his office is under consideration, the deputy speaker shall not, though he is present, preside, and the provisions of clause 2 of article 180 shall apply in relation to every such sitting as they apply in relation to a sitting from which the speaker, or as the case may be, the deputy speaker is absent. 2. The speaker shall have the right to speak in the otherwise to take part in the proceeding of the Legislative Assembly while any resolution for this removal from office is under consideration in the Assembly and shall, notwithstanding anything in Article 189, be entitled to vote only in the first instance on such resolution or on any other matter during such proceeding, but not in the case of any equality of votes. Article 182. The chairman and deputy chairman of the Legislative Council. Article 182. The chairman and deputy chairman of the Legislative Council. The Legislative Council of every state having such council shall, as soon as may be, choose 2 members of the council to be respectively chairman and deputy chairman thereof, and so often as the office of chairman or deputy chairman becomes vacant, the council shall choose another member to be chairman or deputy chairman as the case may be. Article 183. Vacation and resignation of and removal from and offices of chairman and deputy chairman. A member holding office as chairman or deputy chairman of a legislative council A shall vacate his office if he ceases to be member of the council. B may at any time by writing under his hand addressed, if such member is the chairman, to the deputy chairman, and if such member is the deputy chairman, to the chairman, resign his office, and C may be removed from his office by resolution of the council passed by the majority of all the then members of the council, provided that no resolution for the purpose of clause C shall be removed unless at least 14 days notice has been given of the intention to move the resolution. Article 184. Power of the deputy chairman or other person to perform the duties of the office of or to act as chairman. 1. While the office of chairman is vacant, the duties of the office shall be performed by the deputy chairman, or if the office of deputy chairman is also vacant, by such member of the council as the governor may appoint for the purpose. 2. During the absence of chairman from any sitting of the council of deputy chairman, or if he is also absent, such person as may be determined by the rules of procedure of the council, or if no such person is present, such other person as may be determined by the council shall act as chairman. Article 185. The chairman or deputy chairman not to preside while a resolution for his removal from office is under consideration. 1. At any sitting of the Legislative Council, while any resolution for the removal of the chairman from his office is under consideration, the chairman, or while any resolution for the removal of the deputy chairman from his office is under consideration, the deputy chairman shall not, though he is present, preside, and the provisions of the clauses 2 of Article 184 shall apply in relation to every such sitting as they apply in relation to a sitting from which the chairman, or as the case may be, the deputy chairman is absent. 2. The chairman shall have the right to speak in or otherwise to take part in the proceeding of the Legislative Council while any resolution for his removal from office is under consideration in the council, and shall, notwithstanding anything in Article 189, be entitled to vote only in the first instance on such resolution or on any other matter during such proceedings, but not in the case of inequalities of votes. Article 186. Salaries and allowances of the Speaker and Deputy Speaker and the Chairman and Deputy Chairman. There shall be paid to the Speaker and Deputy Speaker of the Legislative Assembly and to the Chairman and the Deputy Chairman of the Legislative Council such salaries and allowances as may be respectively fixed by the legislature of the state by law and until provisions in that behalf is so made, such salaries and allowances as are specified in the second schedule. Article 187. Secretariat of State Legislature. 1. The house of each house of the legislature of the state shall have separate secretarial staff, provided that nothing in this clause shall, in the case of legislature of a state having the legislative council, be construed as preventing the creation of posts common to both houses of such legislature. 2. The legislature or the state may by law regulate the requirement and the condition of service of persons appointed to the secretarial staff of the house or houses of the legislature of the state. 3. Until provision is made by the legislature of the state under clauses 2, the governor may, after consultation with the Speaker of the Legislative Assembly or Chairman of the Legislative Council as the case may be, make rules, regulation, the recruitment and the condition of service of person appointed to the secretarial staff of the Assembly or the Council, and any rules so made shall have effect subject to the provisions of any law made under the said clause. Conduct of business. Article 188. Oath or affirmation by members. Every member of the Legislative Assembly or the Legislative Council of a state shall, before taking his seat, make and subscribe before the governor or some person appointed in that behalf by him an oath or affirmation according to the form set out for the purpose in the third schedule. Article 189. Voting in house. Power of houses to act notwithstanding vacancies and quorum. 1. Saving as otherwise provided in this constitution, all questions at any sitting of houses of legislature of a state shall be determined by the majority of votes of the members present and voting, other than the Speaker or Chairman or person acting as such. The Speaker or Chairman or person acting as such shall not vote in the first instance, but shall have and exercise a casting vote in the case of an inequality of votes. 2. A house of legislature of a state shall have power to act notwithstanding any vacancy in the membership thereof, and any proceeding in the legislature of a state shall be valid notwithstanding that it is discovered subsequently that some person who was not entitled so to do sat or vote or otherwise took part in the proceedings. 3. Until the legislature of the state by law otherwise provided, the quorum to constitute a meeting of a house of the legislature of the state shall be 10 members or 1/10 of the total member of the members of the house, whichever is greater. 4. If at any time during a meeting of the Legislative Assembly or the Legislative Council of a state there is no quorum, it shall be duty of the Speaker or Chairman or person acting as such either to adjourn the house or to suspend the meeting until there is a quorum. Disqualifications of members. Article 190. Vacation of seats. 1. No person shall be a member of both House of Legislature of a state and provision shall be made by the legislature of the state by law for the vacation by a person who is chosen a member of both houses of his seat in one house or the other. 2. No person shall be a member of legislatures of two or more states specified in the first schedule, and if a person is chosen a member of the legislatures of two or more such states, then at the expiration of such period as may be specified in rules made by the president, that person's seat in the legislatures of all such states shall become vacant unless he has previously resigned his seat in the legislature of all but one of the states. 3. If a member of the House of Legislature of a state A becomes subject to any of the qualifications mentioned in clauses 1 or clauses 2 of Article 191, or B resign his seat by writing under his hand addressed to the Speaker or Chairman as the case may be, and his resignation is accepted by the Speaker or Chairman as the case may be, his seat shall thereupon become vacant, provided that in the case of resignation referred to in subclause B, if from information received or otherwise, and after making such inquiry as he think fit, the Speaker or the Chairman as the case may be is satisfied that such resignation is not voluntary or genuine, he shall not accept such resignation. 4. If for the period of 6 days a member of a house of the legislature of a state is without permission of the house absent from all meeting thereof, the house may declare his seat vacant, provided that in computing the said period of 60 days no account shall be taken of any period during which the house is prorogued or is adjourned for more than 4 consecutive days. Article 191. Disqualification of membership. 1. A person shall be disqualified for being chosen as and for being a member of the Legislative Assembly or Legislative Council of a state. A. If he holds any office of profit under the government of India or the government of any state specified in the first schedule other than an office declared by the legislature of a state by law not to disqualify its holder. B. If he is the unsound mind and stand so declared by the competent court. C. If he is an undischarged insolvent. D. If he is not a citizen of India or has voluntarily acquired the citizen of a foreign state or is under any acknowledgement of allegiance or adherence to the foreign state. E. If he is so disqualified by or under any law made by Parliament. Explanation. For the purpose of this clause, persons shall not be deemed to hold an office of profit under the government of India or government of any state specified in the first schedule by the reason only that he is the minister either for the union or for such state. 2. A person shall be disqualified for being member of legislative assembly or legislative council for a state of he is so disqualified under the 10th schedule. Article 192. This decision on questions as to disqualification of members. 1. If any questions arise as to whether a member of a house of the legislature of a state has become subject to any of the disqualification mentioned in clauses 1 or article 191, the question shall be referred for the decision of the governor and his decision shall be final. 2. Before giving any decision on any such question, the governor shall obtain the opinion of the election commission and shall act according to such opinion. Article 193. Penalty for sitting and voting before making oath or affirmation under Article 188 or when not qualified or when disqualified. If a person sits or votes as a member of the legislative assembly or legislative council of a state before he has complied with the requirements of Article 188 or when he knows that he is not qualified or that he is disqualified for membership thereof or that he is prohibited from so doing by the provisions of any law made by parliament or legislature of the state, he shall be liable in respect of each day on which he sits or votes to penalty of 500 rupees to be recovered as debt due to the state. Powers, privileges and immunities of state legislatures and their members. Legislatures and their members. Powers, privileges and immunities of state legislatures and their members. Article 194. Power, privileges, etc. of the House of Legislatures and of the members and committees thereof. 1. Subject to the provisions of the Constitution and to rules and standing order regulating the procedure of the legislature, there shall be freedom of speech in the legislature of every state. 2. No member of the legislature of a state shall be liable to any proceeding in any court in respect of anything said or any vote given by him in the legislature or any committee thereof, and no person shall be so liable in respect of the publication by or under the authority of a house of such a legislature of any report, paper, votes or proceedings. 3. In other respects, the powers, privileges and immunities of a house of legislature of a state and of the members and the committees of the house of such legislature shall be such as may from time to time be defined by the legislature by law, and until so defined shall be those of that house and of its members and committees immediately before the coming into force of section 26 of the Constitution, 44th Amendment Act 1978. 4. The provisions of clauses 1, 2 and 3 shall apply in relation to person who is virtue of this Constitution have the right to speak in and otherwise to take part in proceedings of a house of the legislature of a state or any committee thereof as they apply in relation to members of the legislature. Article 195. Salaries and allowances of members. Article 195, salaries and allowances of members. Members of the Legislative Assembly and the Legislative Council of a state shall be entitled to receive such salaries and allowances as may from time to time be determined by the legislature of a state by law, and until provisions in that respect is so made, salaries and allowances at such rates and upon such condition as were immediately before the commencement of this constitution applicable in the case of members of the Legislative Assembly of the corresponding province legislative procedure. Article 196, provisions as to introduce and passing of bills. Article 196, provisions as to introduce and passing of bills. A. Subject to the provisions of Articles 198 and 207 with respect to money bills and other financial bills, a bill may originate in either house of legislature of a state which has legislative council. 2. Subject to the provisions of Article 197 and 198, a bill shall not be deemed to have been passed by the house of legislature of a state having legislative council unless it has been agreed to by both houses, either without amendment or with such amendments only as are agreed to by both houses. 3. A bill pending in the legislature of a state shall not lapse by reasons of the prorogation of the house or houses thereof. 4. A bill pending in the Legislative Council of the state which has not been passed by the Legislative Assembly shall not lapse on the dissolution of the Assembly. 5. A bill which is pending in the Legislative Assembly of a state or which having been passed by the Legislative Assembly is pending in the Legislative Council shall lapse on the dissolution of the Assembly. Article 197, restriction on powers of Legislative Council as to bills other than money bills. If after a bill has been passed by the Legislative Assembly of a state having a Legislative Council and transmitted to the Legislative Council, A. The bill is rejected by the Council, or B. More than 3 months elapse from the date on which the bill is laid before the Council without the bill being passed by it, or C. The bill is passed by the Council with amendments to which the Legislative Assembly does not agree. The Legislative Assembly may, subjected to the rules regulation its procedure, pass the bill again in the same or in any subsequent session with or without such amendments, if any, as have been made, suggested or agreed to by a Legislative Council, and then transmit the bill as so passed to the Legislative Council. 2. If after a bill has been so passed for the second time by the Legislative Assembly and transmitted to the Legislative Council, A. The bill is rejected by the Council, or B. More than 1 month elapsed from the date on which the bill is laid before the Council without the bill being passed by it, or C. The bill is passed by the Council with the amendments to which the Legislative Assembly does not agree. The bill shall be deemed to have been passed by the House of Legislature of the state in the form in which it was passed by the Legislative Assembly for the second time, with such amendments, if any, as have been made or suggested by the Legislative Council and agreed to by the Legislative Assembly. 3. Nothing in this article shall apply to a money bill. Article 198. Special procedure in respect of money bills. 1. A money bill shall not be introduced in a legislative council. 2. After a money bill has been passed by the legislative assembly of a state having a legislative council, it shall be transmitted to the legislative council for its recommendation, and the legislative council shall, within the period of 14 days from the date of its receipt of the bill, return the bill to the legislative assembly with its recommendation, and the legislative assembly may return thereupon either accept or reject all or any of the recommendation of the legislative council. 3. If the legislative assembly accepts any of the recommendation of the legislative council, the money bill shall be deemed to have been passed by both house with amendments recommended by the legislative council and accepted by the legislative assembly. 4. If the legislative assembly does not accept any of the recommendation of the legislative council, the money bill shall be deemed to have been passed by both houses in the form which it was passed by the legislative assembly without any of the amendments recommended by the legislative council. 5. If a money bill passed by the legislative assembly and transmitted to the legislative council for its recommendation is not returned to the legislative assembly within the said period of 14 days, it shall be deemed to have been passed by the both houses at the expiration of the said period in the form in which it was passed by the legislative assembly. Article 199. Definition of money bills. 1. For the purpose of its chapter, a bill shall be deemed to be a money bill if it contains only provisions dealing with all or any of the following matters, namely: A. The imposition, abolition, remission, relation or regulation of any taxes, any tax. B. The regulation of borrowing of money or the giving of any grantee of by the state, or the amendment of the law with respect to any special obligation undertaken or to be undertaken by the state. C. The custody of the consolidated fund or the contingency fund of the state, the payment of monies into or the withdrawal of monies from any such fund. D. The appropriation of monies out of consolidated fund of the state. E. The declaration of any expenditure to be expenditure charged on the consolidated fund of the state, or the increasing of the amount of any such expenditure. F. The receipt of money on account of consolidated fund of the state or public account of the state, or the custody or issue of such money. Or G. Any matter incidental to any of the matters specified in some clauses A to F. 2. A bill shall not be deemed to be a money bill by reason only that it provides for the imposition of fines or other pecuniary penalties, or for the deemed or payment of fees for license or fees for services rendered or by region that it provides for the imposition, abolition, remission, relation or regulation of any tax by any local authority or body for local purposes. 3. If any questions arise whether a bill introduced in the legislature of a state which has a legislative council is a money bill or not, the decision of Speaker of a legislative assembly of such state thereon shall be final. For there shall be endorsed on every money bill when it is transmitted to legislative council under article 198 and when it is presented to the governor for assent under article 200, the certificate of the speaker of the legislative assembly signed by him that it is the money bill. Article 200. Assent to bills. When a bill has been passed by the legislative assembly of a state or in the case of state having legislative council has been passed by both houses of the legislature of the state, it shall be presented to governor and the governor shall declare either that he assents to the bill or that he withhold assent therefrom or that he reserve the bill for the consideration of the president, provided that the governor may as soon as possible after the presentation to him or bill for the assent return the bill if it is not money bill, together with the message requisiting that the house or houses will consider the bill or any specified provisions thereof, and the particulars will consider the desirability of introducing any such amendment as he may recommend in his message, and when a bill is so returned, the house or houses shall reconsider the bill accordingly, and if the bill is passed again by the house or houses with or without amendment and presented to the governor for assent, the governor shall not withhold assent therefrom, provided further that the governor shall not assent to but shall reserve for the consideration of the president any bill which in the opinion of the governor would, if it become law, so derogate from the powers of the High Court as the endanger the position which the court is by the Constitution designed to fill. Article 201. Bills reserved for consideration. When a bill is reserved by the governor for the consideration of the president shall declare either that he assents to the bill or that he withhold assent therefrom. Provided that where the bill is not a money bill, the president may direct the governor to return the bill to the house, or as the case may be, the houses of the legislature of state together with such a message as is mentioned in the first proviso, the article 200, and when a bill is so returned, the house or house shall consider it accordingly with a period of 6 months from the date of receipt of such message, and if it is again passed by the house or houses with or without amendment, it shall be presented again to the president for his consideration. Procedure in financial matters. Article 202. Article 202. Annual financial statement. Procedure in financial matters. Article 202, annual financial statement. 1. The governor shall, in respect of every financial year, cause to be laid before the house or houses of legislature of the state, or a statement of the estimated receipts and expenditure of the state for that year in the part referred to as the annual financial statement. 2. The estimates of expenditure embodied in the annual financial statement shall show separately: A. The sums required to meet expenditure described by this constitution as expenditure charged upon the consolidated fund of the state, and B. The sum required to meet other expenditure proposed to be made from the consolidated fund of the state, and shall distinguish expenditure on revenue account from the other expenditure. 3. The following expenditure shall be expenditure charged on the consolidated fund of each state. A. The emoluments and allowances of the governor and other expenditure relating to his office. B. The salaries and allowances of Speaker and Deputy Speaker of the Legislative Assembly, and in the case of a state having a legislative council, also of the chairman and the deputy chairman of the legislative council. C. Debt charges for which the state is liable, including interest, sinking fund charges, and redemption charges, and other expenditure relating to the raising of loans and the services and redemption of debt. D. Expenditure in respect of salaries and allowances of judges of the High Court. E. Any sums required to satisfy any judgment, decrees, or award of any court or arbitral tribunal. F. Any other expenditure declared by this constitution or by the legislature of the state by law to be so charged. Article 203. Procedure in legislature with respect to estimates. 1. So much of the estimates as relates to expenditure charged upon the consolidated fund of a state shall not be submitted to the vote of the legislative assembly, but nothing in this clause shall be construed as preventing the discussion in the legislature of any of those estimates. 2. So much of the said estimates as relates to the expenditure shall be submitted in the form of demands for grants to the legislative assembly, and the legislative assembly shall have power to assent or to refuse to assent to any demand, or to assent to any deemed subject to a reduction of amount specified therein. 3. No demand for grant shall be made except on the recommendation of the governor. Article 204. Appropriation bills. 1. As soon as may be after the grants under Article 203 have been made by the Assembly, there shall be introduced a bill to provide for the appropriation out of consolidated fund of the state of all monies required to meet: A. the grant so made by assembly, and B, the expenditure charged on the consolidated fund of the state but not exceeding in any case the amount shown in the statement previously laid before the house or houses. 2. No amendment shall be proposed to any such bills in the house of either house of the legislature of the state which will have the effect of verifying the amount or altering the distinction of any grant so made or of varying the amount of any expenditure charged on the consolidated fund of the state, and the decisions of the person presiding as to whether the amendment is inadmissible under this clause shall be final. 3. Subject to the provisions of Article 205 and 206, no money shall be withdrawn from the consolidated fund of the state except under appropriation made by law passed in accordance with the provisions of this article. Article 205, Supplementary, Additional or Excess Grant. 1. The governor shall A. If the amount authorized by any law made in accordance with the provisions of Article 204 to be expended for the particular service for the current financial year is found to be insufficient from the purpose of that year, or when a need has arisen during the current financial year for supplementary or additional expenditure upon some new service not contemplated in the annual financial statement for that year, or B, if any money has been spent or any service during the financial year is excess of the amount granted for the service and for that year, cost to be laid before the house or the houses of legislature of the state another statement showing that estimated amount of that expenditure or cost to be presented to the legislative assembly of the state, a demand of such excess as the case may be. 2. The provisions of Article 202, 203 and 204 shall have effect in relation to any such statement and expenditure or demand, and also to any law to be made authorized and appropriation of monies out of the consolidated fund of the state or to meet such expenditure or the grant in respect of such deemed as they have effect in relation to the annual financial statement and the expenditure mentioned therein, or to a demand for grant and the law to be made for the authorization and appropriation of monies out of the consolidated fund of the state to meet such expenditure or grant. Article 206. Article 206, votes on account, votes on credit and exceptional grants. 1. Notwithstanding anything in the foregoing provisions of this chapter, the Legislative Assembly of the State shall have power A. To make any grant in advance in respect of estimated expenditure for a part of any financial year pending to completion of the procedure prescribed in Article 203 for the voting of such grant and the passing of the law accordance with the provisions of Article 204 in relation to that expenditure. B. to make a grant for meeting an unexpected demand upon the resources of the state, when on account of the magnitude or indefinite character of the services, the demand cannot be stated with the details ordinarily given in an annual financial statement. C. To make an exceptional grant which form no part of the current services of any financial year, and the legislature of the state shall have power to authorize by law or withdrawal of monies from the consolidated fund of the state for the purpose for which the said grants are made. 2. The provisions of Article 203 and 204 shall have effect in relation to the making of any grant under clauses 1 and to any law to be made under the clauses as they have effect in relation to the making of a grant with regard to any expenditure mentioned in the annual financial statement, and the law to be made for the authorization of appropriation of monies out of consolidated fund of the state to meet such expenditure. Article 207. Special provisions as to financial bills. 1. A bill or amendment making provisions for any of the matter specified in subclauses A to F of clauses 1 of Article 199 shall not be introduced or removed except on the recommendation of the governor, and bill making such provisions shall not be introduced in legislative council, provided that no recommendation shall be required under this clause for the moving of an amendment making provision for the reduction or abolition of any tax. 2. A bill or amendment shall not be deemed to make provisions for any of the matter aforesaid by reason only that it provides for the imposition of fines or other pecuniary penalties, or for the demand or payment of fee for license, of fee for services rendered, or by reason that it provides for the imposition, abolition, remission, alteration, or regulation of any tax by any local authority or body or local purposes. 3. A bill which, if enacted and brought into operation, would involve expenditure from the consolidated fund of a state shall not be passed by a house of a legislature of the state unless the governor has recommended to the house of consideration of the bill. Procedure generally. Procedure generally. Article 208. Rules of procedure. 1. A house of legislature of a state may make rules of regulating subject to the provisions of this constitution, its procedure and conduct of its business. 2. Until rules are made under clauses 1, the rules of procedure and standing order in force immediately before the commencement of its constitution with respect to a legislature for the corresponding province shall have effect in relation to the legislature of the state, subject to such modifications and adaptations as may be made therein by the Speaker of the Legislative Assembly or the Chairman of the Legislative Council as the case may be. 3. The state having legislative council of the governor after consolidated with the speaker of the legislative assembly and the chairman of the legislative council may make rules as the procedure with respect to communications between the two houses. Article 209 Regulation by law procedure in legislature of the state in relation to financial business. The legislature of the state may, for the purpose for the timely completion of financial business, regulate by law the procedure of and the conduct of business in the house or houses of the legislature of the state in relation to the financial matter or to any bill for the appropriation of monies out of the consolidated fund of the state, and so far as the provision of a law is made inconsistent with any rule made by the house or either house of the legislature of the state under clauses 1 or article 208 or with any rule or standing order having effect in relation to the legislature of the state under clauses 2 of that article, such provision shall prevail. Article 210 Language to be used in the legislature. 1. Notwithstanding anything in part 17 but subjected to the provisions of article 348, business in the legislature of the state shall be transacted into official language or languages of the state or in Hindi or in English, provided that the speaker of legislative assembly or chairman of the legislative council or person acting as such as the case may be may permit any member who cannot adequately express himself in any of the languages aforesaid to address the houses in the mother language. 2. Unless the legislature of the state by law otherwise provides, this article shall, after the expiration of the period of 15 years from the commencement of this constitution, have effect as if the words or in the English were omitted therefrom. Provided that in relation to legislation of the state Himachal Pradesh, Manipur, Meghalaya and Tripura, this clause shall have effect as if for the word 15 years occurring therein, the word 25 years were substituted. Provided further that in relation to the legislature of state of Arunachal Pradesh, Goa and Mizoram, the clauses shall have effect as if for the words 15 years occurring therein, the words 15 years were substituted. Article 211 Restriction on discussion in the legislature. No discussion shall take place in the legislature if a state with respect to the conduct of any judge of Supreme Court or the High Court in the discharge of his duties. Article 212 Courts not to inquire into proceedings of legislature. 1. The validity of any proceedings in legislature of a state shall not be called in questions on the ground of any alleged irregularities of procedure. 2. No officer or member of the legislature of the state in whom powers are vested by or under this constitution for regulating procedure or conduct of business or maintaining order in the legislature shall be subjected to the jurisdiction of any court in respect of exercise by him of those powers. Chapter 4 Legislative Power of the Governor. Article 213 Power of Governor to promulgate ordinance during recess of legislature. 1. If at any time except when the legislative assembly of a state is in a session or where there is a legislative council in a state, except when both houses of legislature are in session, the governor is satisfied that circumstances exist which render it necessary for him to take immediate action. He may promulgate such ordinances as the circumstances appears to him to require, provided that the governor shall not, without instruction from the president, promulgate any such ordinance if a bill containing the same provisions would under the constitution have required the provisions sanction of the president for the introduction thereof into the legislature, or B. He would have deemed it necessary to reserve a bill containing the same provisions for the consideration of the president, or C. An act of the legislature of a state containing the same provisions would under this constitution have been invalid unless, having been reserved for the consideration of the president, it had received the assent of the president. 2. An ordinance promulgated under this article shall have the same force and effect as an act of the legislature of the state assented to by the governor, but every such ordinance A. shall be laid before the legislative assembly of the state, or where there is a legislative council in the state, before both the houses, and shall cease to operate at the expiration of 6 weeks from the reassembly of the legislature, or if before the expiration of that period a resolution disapproving it is passed by the legislative assembly and agreed to by the legislative council, if any, upon the passing of the resolution, or as the case may be, on the resolution being agreed to by the council, and B. may be withdrawn at any time by the governor. Explanation. Where the houses of the legislature of a state having a legislative council are summoned to reassemble on different dates, the period of 6 weeks shall be reckoned from the later of those dates for the purpose of this clause. 3. If and so far as an ordinance under this article makes any provision which would not be valid if enacted in an act of the legislature of the state assented to by the governor, it shall be void, provided that for the purpose of the provisions of this constitution relating to the effect of an act of the legislature of a state which is repugnant to an act of parliament or an existing law with respect to a matter enumerated in the concurrent list, an ordinance promulgated under this article in pursuance of instructions from the president shall be deemed to be an act of the legislature of the state which has been reserved for the consideration of the president and assented to by him. Chapter 5, the High Courts in the States. Chapter 5, the High Courts in the State. Article 214, the High Courts in the States. There shall be High Court in such a state. Article 215, High Courts to be courts of record. Every High Court shall be a court of record and shall have all the powers of such a court, including the power to punish for contempt of itself. Article 216, Constitution of High Courts. Every High Court shall consist of a Chief Justice and such other judges as the President may from time to time deem it necessary to appoint. Article 217, Appointment and condition of the office of a judge of a High Court. 1. Every judge of a High Court shall be appointed by the President by warrant under his hand and seal on the recommendation of the National Judicial Appointment Commission referred to in Article 224A, and shall hold office in the case of a additional or acting judge as provided in Article 224, and in any other cases until he attains the age of 62 years, provided that a judge may be writing under his hand addressed to the President resign his office. B. A judge may be removed from his office by President in the manner provided in clauses 4 of Article 124 for the removal of a judge of a Supreme Court. C. The office of judge shall be vacated by his being appointed by the President to be judge of the Supreme Court, or his being transferred by the President to any High Court within the territory of India. 2. A person shall not be qualified for appointment as judge of a High Court unless he is a citizen of India and A. has for the least 10 years held judicial office in the territory of India, or B. has for at least 10 years been advocate of a High Court or of 2 or more such courts in succession. Explanation for the purpose of this clause. A. In computing the period during which a person has held judicial office in the territory of India, there shall be included any period after he has held any judicial office during which the person has been an advocate of a High Court or has held the office of a member of a tribunal or any post under the union or state requiring special knowledge of law. double A. In computing the period during which a person has been an advocate of a high court, there shall be included any period during which a person has held judicial office or the office of a member of a tribunal or any post under union or state requiring special knowledge of law after he become an advocate. B. In computing the period during which a person has held judicial office in the territory of India or been an advocate of a high court, there shall be included any period before the commencement of this constitution during which he has held judicial office in any area which had comprised before the 15th day of August 1947 within India as defined by the Government of India Act 1935 or had been advocate of any high court in any such area as the case may be. 3. If any questions arise as the age of judge of a high court, the question shall be decided by the President after consultation with the Chief Justice of India, and the decision of the President shall be final. Article 218. Application of certain provisions relating to Supreme Court to High Courts. The provisions of clauses 4 and 5 of Article 124 shall apply in relation to a High Courts as they apply in relation to the Supreme Court, with the substitution of reference to the High Court for the references to the Supreme Court. Article 219. Oath or affirmation by judges of high courts. Every person appointed to be judge of a high court shall, before he enters upon his office, make and subscribe before the governor of the state or some person appointed in that behalf by him an oath or affirmation according to the form set out for the purpose in the third schedule. 220. Restriction on practice after being permanent judge. No person who after the commencement of this constitution has held office as a permanent judge of the High Court shall plead or act in any court or before any authority in India except Supreme Court and the other high courts. Explanation. In this article, the expression high court does not include a high court for a state specified in part B of the first schedule as it existed before the commencement of the Constitution, 7th Amendment Act 1956. Article 221. Salaries etc. of judges. Article 221. Salaries etc. of judges. 1. There shall be paid to the judges of each high court such salaries as may be determined by the Parliament by law, and until provision in that behalf is so made, such salaries as are specified in the second schedule. 2. Every judge shall be entitled to such allowances and such rights in respect of leave or absence and pensions as may from time to time be determined by or under law made by Parliament, and until so determined to such allowances and rights as are specified in this second schedule, provided that neither the allowances of a judge nor his rights in respect of leave of absence or pension shall be varied to his disadvantage after his appointment. Article 222. Transfer of judge from the High Court to another. 1. The President may, on the recommendation of National Judicial Appointment Commission referred to in Article 124A, transfer a judge from one high court to any other high court. 2. When a judge has been been or is so transferred his cell during the period he serves after the commencement of the Constitution 15 Amendment Act 1963 as a judge of the other High Court be entitled to receive in addition to his salary such compensatory allowances as may be determined by Parliament by law and until so determined such compensatory allowances as the President may by order fix. Article 223 Appointment of Acting Chief Justice. When the office of Chief Justice of High Court is vacant or when any such Chief Justice is by reason of absence or otherwise unable to perform the duties of his office, the duties of the office shall be performed by such one of the other judges of the court as the President may appoint for the purpose. Article 224 Appointment of Additional and Acting Judges. 1. If by reason of any temporary increase in the business of the High Court or by reason of areas of work therein it appears to be President that the number of the judges of the court should be for the time being increased, the President may, in consultation with the National Judicial Appointment Commission, appoint a duly qualified person to be additional judges of the court for such period not exceeding 2 years as he may specify. 2. When any judge of High Court other than the Chief Justice is by reason of absence or for any other reason unable to perform the duties of his office or is appointed to act temporarily as Chief Justice, the President may, in consultation with the National Judicial Appointment Commission, appoint a duly qualified person to act as judge of the court until the permanent judge has resumed his duties. 3. No person appointed as additional or acting judge of a high court shall hold office after attaining the age of 62 years. Article 224A Appointment of retired judges at sitting of high courts. Notwithstanding anything in this chapter, the National Judicial Appointments Commission on the reference made to it by the Chief Justice of High Court or any state may with the provisions consent of the President request any person who has held the office of judge of the court or of any other high court to sit and act as judge of the high court for the state and every such person so requested shall while so sitting and acting be entitled to such allowances as the President may by order determine and have all the jurisdiction's powers and privileges of but shall not otherwise be deemed to be a judge of high court, provided that nothing in this article shall be deemed to require any such person as aforesaid to sit and act as judge of the high court unless he consents so to do. Article 225 Jurisdiction of existing high courts. Article 225 Jurisdiction of existing high courts. subjected to the provisions of the Constitution and to the provisions of any law of the appropriate legislature made by virtue of powers conferred on that legislature by the Constitution. The jurisdiction of and the law administered if any existing High Court and the respective power of the judges thereof in relation to the administration of justice in the court include any power to make rules of court and to regulate the sitting of court and of members thereof sitting alone or the division courts shall be the same as immediately before the commencement of the Constitution, provided that any restriction to which the exercise of original jurisdiction by any of the High Courts with respect to any matters concerning the revenue or concerning any act ordered or done in the collection thereof was subjected immediately before the commencement of this Constitution shall no longer apply to the exercise of such jurisdiction. Article 226, Power of High Courts to issue certain writs. 1. Notwithstanding anything in Article 32, every High Court shall have power throughout the territories in relation to which it exercises jurisdiction to issue to any person or authority, including in appropriate cases any government with those territories, directions, order or writs, includes writs in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari or any of them for the enforcement of any of the rights conferred by Part 3 and for any other purpose. 2. The power conferred by clauses 1 to issue directions, orders or writs to any government, authority or person may also be exercised by a High Court exercising jurisdiction in relation to the territories within which the cause of action wholly or in part arises for the exercise of such power, notwithstanding that the seat of such government or authority or residence of such person is not within those territories. 3. Where any party against whom an interim order, whether by a way of injunction or stay or in any other manner, is made on or any proceeding relating to or petition under clauses 1 without a. Furnishing to such party copies of such petition and all documents in support the plea of such interim order, and b. Giving such party an opportunity of being heard. Makes an application to High Court for the vacation of such order and furnishes a copy of such application to the party in whose favor such order has been made or the counsel of such party. The High Court shall dispose of the application within a period of 2 weeks from the date on which it is received or from the date on which the copy of such application is so furnished, whichever is later, or where the High Court is closed on the last day of that period before the expiry of that next day afterwards on which the High Court is open, and if the application is not so disposed of, the interim order shall on the expiry of that period, or as to case may be, the expiry of said next day stand vacated. 4. The power conferred on a High Court by this article shall not be the derogation of the power conferred on the Supreme Court by clause 2 of Article 32. Article 226A. Constitutional validity of central laws not to be considered in proceedings under Article 226 REP by the Constitution 43rd Amendment Act 1977 as at WEF 13/4/1978. Article 227. Power of superintendence over all courts by the High Court. Article 227. Power of Article 227. Power of superintendence over all courts by the High Court. Every High Court shall have superintendence over all courts and tribunals throughout the territories in relation to which it exercises jurisdiction. 2. Without prejudice to the generality of the foregoing provisions, the High Court may a. Call for returns from each courts, b. Make and issue general rules and prescribe form for regulating the practice and proceedings of such courts, and c. Prescribe forms in which books, entries and accounts shall be kept by the officers of any such courts. 3. The High Court may also settle tables of fees to be allowed to the sheriff and all clerks and officers of such courts, and to attorneys, advocates and pleaders participating therein, provided that any rules made from prescribed or tables settled under clauses 2 or clauses 3 shall not be inconsistent with the provisions of any law for the time being in force, and shall require the provisions approval of the governor. 4. Nothing in this article be deemed to conferred on a High Court powers of superintendence over any court or tribunal constituted by or under any law relating to the armed forces. Article 228. Transfer of certain cases to High Court. If the High Court is satisfied that a case pending in a court subordinate to it involves substantial questions of law as to the interpretation of this Constitution, the determination of which is necessary for the disposal of the case, it shall withdraw the cases and may a. either dispose of the cases itself, or b. determine the said questions of law and return the case to the court from which the case has been so withdrawn, together with a copy of its judgment on which questions, and the said court shall on receipt thereof proceed to dispose on the case of conformity with such judgment. Article 228A. Special provisions as to disposal of questions relating to constitutional validity of state laws. REP by the Constitution 43rd Amendment Act in 1977, Section 10, WEF 13/4/1978. Article 229. Officers and servants and to expenses of High Courts. 1. Appointments of officers and servants of a high court shall be made by the chief justice of court on such other judge or officer of the court as he may direct, provided that governor of the state may by rule require that in such cases as may be specified in the rule no person not already attached to the court shall be appointed to any office connected with the court save after consultation with the State Public Service Commission. 2. Subject to the provisions of any law made by the legislature of the state, the condition of service of officer and servants of High Court shall be such as may be prescribed by rules made by the Chief Justice of the court or by some other judges of officers of the court authorized by the Chief Justice to make rules for the purpose, provided that the rules made under this clause shall so far as they relates to salaries, allowances, leaves or pensions require the approval of the governor of state. 3. The administrative expenses of a high court, including all salaries, allowances and pensions payable to or in respect of the officers and servants of the court, shall be charged upon the consolidated fund of this state, and any fees or other monies taken by the court shall form part of the fund. Article 230. Extension of jurisdiction of high courts to union territories. 1. Parliament may by law extend the jurisdiction of high court to or exclude the jurisdiction of high court from any union territory. 2. Where the high court of a state exercise jurisdiction in relation to a union territory. A. Nothing in this constitution shall be construed as empowering the legislature of a state to increase, restrict or abolish that jurisdiction, and B. The reference in Article 227 to the governor shall in relation to any rules, forms or tables or subordinate courts in that territory be construed as a reference to the president. Article 231. Establishment of a common high court for two or more states. 1. Notwithstanding anything contained in the preceding provisions of this chapter, Parliament may by law establish a common high court for two or more states or for two or more states and union territory. 2. In relation to any high court. B. The reference in Article 227 to the governor shall in relation to any rules, forms or tables of subordinate courts be construed as a reference to the governor of the state in which the subordinate courts are situate, and C. The reference in Article 290 to 229 to the state shall be construed as a reference to the state in which the High Court has its principal seat, provided that if such principal seat is a union territory, the reference is Article 290 to 229 to the governor, Public Service Commission, legislature and consolidated fund of the state shall be construed respectively as a reference to the president, Union Public Service Commission, Parliament and consolidated fund of India. Chapter 6. Subordinate courts. Article 233. Appointment of district judges. 1. Appointments of persons to be and the posting and promotion of district judges in any state shall be made by the governor of the state in consultation with the High Court exercising jurisdiction in relation to such state. 2. A person not already in the service of the union or a state shall only be eligible to appointed a district judge if he has been for not less than 7 years an advocate or a pleader and is recommended by higher court for appointment. Article 233A, validation of appointments of and judgments etc. delivered by certain district judges, notwithstanding any judgment, decree or order of any court. A1. No appointment of any person already in judicial service of a state or any person who has been for not less than 7 years an advocate or a pleader to be a district judge in that state, and 2. No posting, promotion or transfer of any such person as a district judge made at any time before the commencement of the Constitution, 20th Amendment Act 1966, otherwise than in accordance with the provisions of Article 233 or Article 235 shall be deemed to be illegal or void, or ever to have become illegal or void by reason only of the fact that such appointment, posting, promotion or transfer was not made in accordance with the said provisions. B. No jurisdiction exercised, no judgment, decree, sentence or order passed or made, and no other act or proceeding done or taken before the commencement of the Constitution, 20th Amendment Act 1966, by or before any person appointed, posted, promoted or transferred as a district judge in any state otherwise than in accordance with the provisions of Article 233 or Article 235 shall be deemed to be illegal or invalid, or ever to have become illegal or invalid by reason only of the fact that such appointment, posting, promotion or transfer was not made in accordance with the said provisions. Article 234, recruitment of person other than district judges to the judicial services. Appointments of persons other than the district judges to the judicial service of a state shall be made by the governor of the state in accordance with the rules made by him in that behalf, after consultation with the State Public Service Commission and with the High Court exercising jurisdiction in relation to such state. 235. Control over subordinate courts. Article 235. Control over subordinate courts. The control over district courts and courts subordinate thereto, including the posting and promotion of and the grant of leave to person belonging to the judicial service of a state and holding any post inferior to the post of district judge shall be vested in the High Court, but nothing in this article shall be construed as taken away from any such person any right of appeal which he may have under the law regulating the condition of his service, or as authorizing the High Court to deal with him otherwise than in accordance with the conditions of his service prescribed under such law. Article 236. Interpretation in this chapter. A. The expression district judge includes judge of city civil court, additional district judge, joint district judge, assistant district judge, chief judge of a small court, chief presidency magistrate, additional chief presidency magistrate, session judge, additional sessions judge and assistant sessions judge. B. The expression judicial service means a service consisting exclusively of persons intended to fill the post of district judge and other civil judicial posts inferior to the post of district judge. Article 237. Application of the provisions of this chapter to certain class or classes of magistrates. The governor may by public notification direct that the foregoing provisions of this chapter and any rules made thereunder shall with effect from such date as may be fixed by him in that behalf apply in relation to any class or classes of magistrate in state as they apply in relation to persons appointed to the judicial service of the state, subjected to such exception and modification as may be specified in the notification. Part 7. The state in Part B of the first schedule REP by the Constitution 7th Amendment Act 1957 Section 29 and SCH.